Just waiting for Mr. Lee and Mr. Hamlin. Looks like they may be joining us. All right, we'll go on the record. This is CR 2025-232, State of Arizona versus Richard Baptiste and Alicia Woods. We have present on the Zoom call, Mr. Baptiste from the county jail, Ms. Woods from the county jail, Mr. Hamlin, counsel for Mr. Baptiste is present here in the courtroom. Mr. Lee, counsel for Ms. Woods is present here in the courtroom. Mr. Friedley from the county attorney's office is here in the courtroom. Ms. Collins and Mr. Roach are present on the Zoom call. Ms. Clace, counsel for victims, is present on the Zoom call. And I believe other than staff, those are all of our parties and appearances today. Date and time set for a case management status conference in this case. Mr. Hamlin, I'll start with you unless you'd like me to go somewhere else first. Any issues that you need to address in this case on behalf of your client today?
Judge, just a couple things that I haven't received. I'm not sure if they've been completed yet. One is the autopsy. The other would be, looks like counsel requested the transcript from the preliminary hearing, which was done, well, roughly a month prior to me being appointed. I don't see that either of those things. I don't have them. I don't know if they've been completed or not.
All right, thank you. And just to sample, Miss Collins, were you able to hear Mr. Hamlin there?
Yes, Your Honor.
All right, thank you. Mr. Lee, those issues, any others that you need to address for today?
Well, those issues are really the nut of this. We don't have a preliminary hearing transcript, and now the time for filing a motion for a new finding of probable cause has gone because we still don't have it. And so I'd ask the court to extend the time just till we get the transcript before that's shut off to us. And also the autopsy report, which is the very first hearing we had, we requested that, and we still don't have that. And that's holding up, you know, the stance of our defense and everything until we know what the cause of death was.
Right. All right. I do have those noted, and I will try to address all of those issues. Ms. Collins or Mr. Roach, I have a couple of questions for you and then other issues that you need to address. I don't know if there's a preference for who I address those to.
You can go ahead and ask your questions first, Judge. And Brad or I can help, but I can speak for right now.
All right. Regarding the autopsy, I will just note, I think all the parties are aware just from filings, but the state did file a subpoena with requests for court signature regarding, at least in part, or maybe in total, addressing the autopsy. Just in my experience, Ms. Collins, I'm not worried about the subpoena issue, but as far as timing, what information do you have? Is there any particular specified holdup regarding that? I know getting the analysis done sometimes can take some time. I don't know if there is toxicology or otherwise, but anyway, in my experience, usually I think we would have that autopsy report prior to this time. What do you know about that?
So, Judge, when the case first started, we reached out to the Maricopa County Medical Examiner's Office rather early. We were told at minimum it would be 3 months before we were to receive it. There is an additional motion protecting it, I think, under the circumstances. And so that is where the subpoena in which we asked Your Honor to sign. And then the language in there was very specifically based on what they had told us to request so that we could request everything. So right now we are just waiting. And again, Judge, I think you said it with the circumstances. I think it's taking some additional time for them to review. They receive the police reports and whatever else that they need to look at before they can make their final report.
All right. And have they given you any kind of a firm update, or is it very generic in general?
It is very generic, and because of the sealing of the records or the report, I think gives us very little to ask specifics, even as the state.
All right. So, and the parties can, of course, if they need to address it further, by my counting, just in strict numbers, I don't know when they actually began the autopsy itself, but based on the alleged dates of offense, I think we are right at or past, very narrowly, possibly past 90 days from when it may have been able to be started. I don't know then. I do understand the review of information, which I know is we don't always think of as a part of the process for the medical examiner, but I know is a required part of the process is not only the review of the victim, but and the victim's body, but all of the reports and everything that be generated and interesting disclosed to the parties would be relevant for the medical examiner in preparing that autopsy report. So I can understand, I guess, some degree the delay there. It sounds like the contact with the Maricopa County Medical Examiner's Office, I just assume, based on workload, that there already was a delay built in, and those review of documents, disclosure necessary for the autopsy's final reports, probably is just exacerbating that. It's clear to the court that the state is aware of that issue and doing what they can to facilitate and resolve that issue as well. Regarding the preliminary hearing transcript, that's not so much a state issue as a court issue. I can report to the parties. I should have got an update on that in specific, that it was, the court, of course, received that request in order to get the actual transcripts, not just a recording of it, has sent that out to be done. I will try to get an update, or I will ask that the minute entry reflect that I will have staff in my office reach out, perhaps just by a email that would go to all counsel in the case regarding an update on receiving the preliminary hearing transcript with the best information and hopefully deadline by which that should be provided to the parties. Under the circumstances, is there any objection to Mr. Lee's motion to extend the time to request a new probable cause finding to allow him to be able to receive the transcript and then have the time for that to begin to run?
There is no objection from the state, Your Honor.
All right. With no objection, I think that's appropriate under the circumstances. The court will stay the time for the challenge to the probable cause finding preliminary hearing until, and it won't begin to run until those preliminary hearing transcripts are provided to both defense counsel, and then they can review them and decide if they wish to file a motion after that point. Ms. Collins, other issues that you need to address today?
Judge, at this time, the state is ready to set a trial. That's the only issue we've got pending.
All right. And Ms. Clace, I will turn to you. Miss, anything that you need to address regarding anything we've already addressed or anything additional?
Your Honor, I have not been getting copies of any of the filings in this case. Normally I file a notice of appearance, but since I've been appointed by the court, I haven't done that. that I'm happy to file something, whether it's a notice of appearance, if that's required to get the filings, any of the filings by defense counsel.
Were you getting them prior to the consolidation of the case, or has this been throughout?
Throughout.
All right. I will clarify, if it's not clear on the record, then that Ms. Clace is counsel and has made her appearance, whether by paper or not, in the early parts of the case. I don't know, but she is appointed counsel by the court for the victims in the case. And so the court and the clerk's record should always reflect a copy being provided to Ms. Clace on behalf of the victims. And I would ask defense counsel to also copy her on any filings with the court.
Could we get an address then, Judge, right now? We'll do it.
Ms. Clace, do you prefer that by email, or what is best?
Oh, I would, email's totally fine. And I can, if my email address is needed, I'm happy to email the parties counsel and make sure they have my email address.
If you would, just so we don't have to address that on the record right now, after our hearing today, send a copy of a good email address to the email addresses of the counsel in these matters. That would be appreciated.
Of course, Your Honor. Thank you.
All right. Regarding the request to set trial, I know I've heard from defense counsel regarding the disclosure issue. I know that's relevant. Anything additional you'd like to address regarding that, Mr. Lee?
I omitted one. There is another report, Judge, regarding the sexual abuse of the two boys. And that we would like to get a hold of that report as well. I don't know if it's even been issued yet, but we'd like to.
Address that and see if we can find any information out about that in just a moment. Mr. Hamblin, regarding the request to set trial dates, any particular position you would like to address?
I think that's appropriate, Judge.
As we pull up calendars and begin to look at those things, Miss Collins, regarding a report related to sexual abuse of two of the male victims, do you have any information regarding that?
So Judge, approximately a week ago, the state received the DNA report. I think that has several items, including RB's sex assault kit. We have provided everything. I do believe the two boy victims were also included in that initial report. So I'm not entirely sure what is being requested. We also disclosed today, we made a request for the bench notes, which is, I believe, over 300 pages. That's all the notes and stuff from the DNA analyst that has been disclosed today. So I'm not sure if there is something outstanding. It may not have yet been tested. But my recollection is that all three of the victims were a part of the report that was provided to defense a week ago.
All right. I'll just
That's it. Then we'll look at that, Judge, and see if we need any more.
All right. Thank you. I'll just have the parties continue to discuss those issues with ongoing disclosure as it moves forward. All right. And my assistant is also assisting in a trial currently, although Ms. McNeil, are you present on the Zoom call currently?
Yeah.
All right. I believe we've identified through the parties a request for 8 weeks. I think from my perspective, the possibility of that time shortening, I think, does exist, but in order to be safe, we're probably going to look at something around that availability, probably talking about 4-day trial weeks with the calculation of time that the 270-day time limit put us somewhere right at or on the 1st of June of 2026. I don't believe the court has addressed in specific any waivers of time up to this point. Mr. Hamblin, of course, is newer to the case and wasn't counsel throughout. I know Mr. Lee has understandably expressed concern about the disclosure issues and how that relates to trial preparation. But I think the safe thing to do at least would be to try to find those dates that would work. Within that Rule 8 time, at least for now, the court identified a number of potential start dates and times. Some of those, of course, are slipping my mind right now. I believe I would like to look to starting not right against our deadline, but perhaps in the late May time frame. I believe the Memorial Day holiday would be Monday, May the 25th. I'm looking at possibly beginning with jury selection for Wednesday, May the 27th. Because of the Monday holiday that date, I don't want to get rid of the court's ability to continue forward with law and motion calendars. And that would likely be a Tuesday that week. Regarding that start date, I'll just ask there first. Mr. Lee, any objections or issues?
That's a regular day for me, Judge. Not a problem.
All right.
If I have to clear my calendar, I can.
And Mr. Hamblin?
That works, Judge.
Ms. Collins from the state, any issues regarding as far at least as a start date to get moving forward on the case?
So Judge, I would ask to go 1 week further starting. Mr. Roach and I actually just last week had to set a 3-week in custody case that is older, obviously, than this one. That would go, that's the 3 weeks of May, Judge. And so I think the preference would be to start the first week of June, if at all possible. The overlap of the seriousness of it, that is probably, other than this case, Judge, the only other one I really can't move.
I see. All right.
That is, and it's a retrial actually, Judge. So there's a different time limit on it.
Right. And so the state requesting we look into the week Monday, June 1st. I think that week we likely could start June 2nd. Mr. Lee, any objections or issues with that date?
No, sir.
And Mr. Hamlin?
No, Judge.
I will double check and ask my assistant to help me there, but also the parties have their duties regarding Rule 8 time. Again, my recollection was that somewhere near June 1st, and I don't recall if it was on June 1st. At most, it would maybe require a waiver of a day time. With council agreeing to that date, I think we're all right to look there to set. Ms. Clace, are you available at least for a starting time there, looking at June 2nd?
Yes, Your Honor. Thank you.
Finding solid 8 weeks available. I don't know if it's possible on the courts or probably anyone's complete calendar. The one I know of, the mandatory judicial conference that I will be unavailable is the week of the 15th. I think it's the 16th through the 18th of June. Of course, will be a 4th of July holiday. I believe that probably will be observed on the 3rd of July, which is a Friday. So the court is unavailable those dates. Mr. Lee, do you have any other unavailability during the months of June or July that you're aware of?
I don't even have a vacation plan, Judge, so I'm fine with that.
Mr. Hamlin, any other unavailability you're aware of?
I did have a vacation planned, but not anymore.
All right. Ms. Collins, as far as those about 2 months there from the beginning date of June 2nd, any issues on the state's calendar?
I mean, other than the yearly, we have the prosecutors conference. I think it's less mandatory for us as it is for the judicial conference. But I also think that tends to get timed out the same week.
I know they generally try to, but I wonder this week if we're a week before that. I don't know.
But if that's the case, Judge, this can take priority for us. I had a 2-week trial, have a 2-week trial set for the week of the 8th and the week for the 15th. Again, part of the issue that I'm running into, and I'm respecting Rule 8, so we go. But because we had to set this out multiple times before setting a trial date, I had trials added to my calendar. So I will work on that, Judge, but in all candor, that's what's there. But I will work to move that. And so other than the conference, Judge, I do not think there's an issue for scheduling from our perspective. I don't like breaking for a week. I think that's going to make things extremely difficult. If we've got a break for the judicial conference. We had previously been talking also about July setting in earlier hearings. So that said, I respect Rule 8, and if they're asking for a speedy trial, then we will go.
Yeah. Mr. Lee, as far as Rule 8 issues go, do you believe on behalf of your client that you would be objecting to any extenuation beyond the available time right now?
I don't think my client's in a position to waive any time limits, Judge.
All right. Mr. Hamlin, your position as far as extension goes?
Based on discussions with my client, I believe he's of the same position.
All right. And like I say, it is possible that by motion, by decision of the court after hearing from the parties, it is possible that the court could find some Rule 8 time waived prior to today, but I don't think it's really likely, at least that it would be found that both parties have waived time. And so with our consolidated case, I think the safe and best bet probably will be to set this. I don't love the idea of a week vacation in the middle, or a week recess in the middle of the trial. I share that concern, but I'm not sure it can be avoided currently.
Judge, would it be possible to start earlier and end around then?
There are conflicts I'm aware of, both with my schedule, the court schedule, in May. And so I don't think it would be, and the prosecutor just mentioned they've got another priority trial set prior to that during the month of May. So I think if we're looking at that, it would have to be starting in March. There, of course, is some maybe plans regarding spring break or something that might conflict there. I would be willing to look at it if we thought that would work better, but from the court's perspective, the hardest thing is of course, length of it total. finding a consecutive 8 weeks. I am personally, based on very little review of the documents, but just in the experience in the area, I'm hopeful that we'll be able to shrink that total trial time, but I understand why right now the parties may not be able to tell the court that we for sure can.
I would agree with that, Your Honor.
And Ms. Collins, Mr. Roach, as far as you, your perspective, do you have the ability right now on your schedule, if we were to look into March and April, or are there problems there?
I think there will be problems there, Judge. I think what we've got established is going to be the easiest because we've been trying to have everything go ahead to build in a 2-month block for this. So yes, Judge, I think.
Yeah, and I do understand and appreciate the request. I think based on the positions of the parties and my understanding of the court schedule, etc., this is probably as early as we're going to be able to get it off the ground. Ms. Clace, I believe I already asked you about a June 2nd start date. Did I?
You did, Your Honor, and a June 2nd start date is fine, but I would note that 2 of the victims, KB1 and KB2, will likely be unavailable the week of July 19th. I don't anticipate that being a problem, and I can certainly work with the state on their need for when KB1 and KB2 need to be in court.
All right, thank you very much for mentioning that. That, of course, is an important consideration.
Yes, and one more thing, Your Honor, I also, July 23rd and 24th, will be out of state, but if I can have someone else from my office cover that day, or if I can be excused those 2 days, I don't have a problem with this moving forward and prefer that it does move forward on June 2nd.
All right, thank you. I'm very confident that from the court's perspective, there absolutely won't be any issue with coverage. Even if you needed to make yourself completely unavailable that date, I am sure that we could work something out to make that work.
Thank you.
All right, I know it's a bit of a moving target, but I think we've got to firm up what we can. I will, through my staff, prepare an order with more detail. I'll state right now that the court is intending to set trial date to begin Tuesday, June the 2nd. The judicial conference, which again, it is actually by Supreme Court rule mandatory, but perhaps if I gave them enough notice, maybe I can get an exception. I don't know the answer to that question. And I may look into that possibility, but right now it looks like the court likely would not be able to hold any hearings the week of June the 15th, with the possible exception of the 15th itself or the 19th. Those dates, the judicial conference is not ongoing, though there may be other complications for myself as well as, of course, the parties those days. But in general, I'm going to set apart from that June 2nd through July the 31st, which is a Friday, with the court's general plan. Again, hopeful that we do not have to use all of that time. General plan being that court would be, or the trial would be held Tuesdays through Fridays, with a regular beginning time of 8:30. Those might have to be adjusted to 9 o'clock, especially with jurors. We have some jurors that travel 3 or 4 hours to get here to court. So we can, of course, adjust the start date each time, each day, but in general, of course, taking our lunch recess and adjourning for the day by 5 p.m. or earlier, depending on the situation there. Again, I'll note the July 4th holiday. I believe that would be held by the court on Friday, July the 3rd. We won't, of course, have court that date if that's when that is being honored. As far as Apache County juries go, this is right in the middle of summer. That has its downsides for sure, but also its upsides. I don't know. Any 8-week period we select will definitely have issues as far as jury availability, and numbers of juries would have to call to get our valid panel. And I will follow up through my staff with a further order regarding the trial dates with a little bit more specificity, perhaps noting the court's unavailability dates, and I will check into the possibility of whether or not the Supreme Court would authorize a missing of the judicial conference or not. All right, with that addressed, Mr. Lee, anything additional that you need to address for today?
No, sir.
Mr. Hamlin, anything additional for you for today?
No, Judge.
Ms. Collins, anything additional on behalf of the state?
I do have a question and a clarification. I did confirm the disclosure that's been provided to defense covers all 3 of the victims.
All right.
And then in terms of sort of the jury pool, Judge, given the circumstances, has just sort of in a practice with you considered a questionnaire or how many jurors that we will have as a part of our pool. I think I'm taking the opportunity to, I'm kind of just putting it out there at this point, is given the unusual, I think, number we will need. Has that been something the court has considered ahead of today?
Yes, we have considered it. We do use questionnaires in general. We have not had a good system, to be just blunt about it here, about getting those returned prior to the day of trial. I think in a case like this, definitely that would be my plan and hope, is that through the parties, we would work on a questionnaire well in advance, that we would identify a potential jurors pool well in advance and send them that. We have not adopted a electronic version of that where the parties were able to almost in real time see the results of those questionnaires. And our jury veneer, our jury population, we have a number of issues with electronic access, and so we probably will have to have at least a paper option, if not a mandatory requirement of paper for that. But I am very interested in using that, in getting as much information about the jurors, about those who may have a hardship, disqualification, as well as any cause that they should be disqualified, and get that information to the parties as soon as possible, including well before our June 2nd start of actual voir dire would begin. So I do appreciate that. As far as the numbers, we've been worked with the clerk's office, of course, over time, have some idea with a trial this length and potential complexity. I will continue to work with them on those issues, and know that we'll need to figure that out, not only for the actual day of, but also for those questionnaires that we plan to send out. I definitely would plan to send those out maybe 2 months in advance or something like that, to try to get as much information as we can prior to that date.
Thank you, Your Honor.
All right. Ms. Clace, anything additional that you need to address for today?
No, Your Honor, thank you.
I should have set before I went to everyone for the last, I will set a status conference just to check in with the parties and see if there are any issues or assistance needed from the court. I am going to set that. Get past the holidays, hopefully for everyone, if there's any time there. I'm looking at Monday, January the 5th or Monday, January the 12th. I'd like to go again at 11 a.m. Any issues or problems with either of those dates from any of the parties?
No, sir.
The state would prefer the 12th if possible.
All right. And all of the council may appear by Zoom that date. We will set status conference again Monday, January the 12th at 11 a.m. with parties being able to appear by Zoom. All right. Thank you all for your appearance. If there's nothing additional, we will be adjourned in these matters.
Thank you, Judge.
Thank you, Judge.
Thank you.